Have you ever wondered exactly what confidentiality means to a private investigator? If you said yes, then this video is for you. Welcome to the PI Guy, tips, tricks, and advice for professional private investigators just like you. My name is John Morris. I am a licensed professional private investigator in Colorado. Confidentiality is one of the most important things you need to keep in mind when working a case. Not only is confidentiality required in your cases by your licensing, but if confidentiality is broken between you and your client, it could land you in a great deal of trouble from the civil standpoint. Most licensing will require you to keep everything, that is everything, confidential regarding your case and your client's information. Usually there is some sort of clause, though, that does allow you to disclose certain information if your client has provided you with written permission. This confidentiality includes after the case is closed. This is something else you should always keep in mind. So when you get your next juicy case, don't go calling all of your buddies and telling them who you are working for, what you're going to do, and who your client thinks and what they think they're doing. Now, what reasons may there be for breaking confidentiality? Go down in the comments below and let me know your thoughts. I really do want to know. One of the reasons you can break confidentiality is if your client gave you permission. Now, I would obviously want to get this in writing as well. I doubt your client is going to give you permission without good cause or benefit for them. An example may be for a domestic civil case like a divorce, for instance. If I worked a case a while back and caught someone's spouse conducting activities that they were not supposed to be doing, then years down the road, that subject's next spouse hired me, I might want to see if my first client would let me discuss the case with my new client. Now that is a little far-fetched, but I have been contacted in the past by legal counsel regarding the subject of a past investigation asking for more information on my investigation. And in that case, I did reach out to my client and informed her about the situation and asked her if I could share my report and findings with the attorney. She did give me permission, and I did share what information I had, and it was beneficial to the attorney's case against the subject. Another reason that you might consider breaking confidentiality is in the interest of public safety. Now, this might be a bit objective at best. So if I found myself in this situation, I might consider seeking legal advice before I breach that client confidentiality barrier. You can also reveal confidential information to your investigative team too on an as-needed basis. So if I have an investigation for Mr. Smith and I have an investigator that I am assigning surveillance to regarding this case, it is obviously okay for me to tell that investigator the details of the case. In fact, it is incumbent upon me to make sure that investigator has all of the details needed in order to safely and successfully complete the assigned task. But if I have another investigator working a completely unrelated surveillance, it would not be prudent for me to discuss details with that investigator, as there is no need for him or her to know the details. Now, that does not mean mum's the word. I can't talk about it at all. I think it is fine if I was talking to the second investigator and I just mentioned that investigator one was out on a surveillance regarding a domestic situation in the metro area. Saying that does not divulge any secret information such as names, places, things like that. In fact, it would be pretty normal discussions for the most part in regular everyday office chatter in a PI firm. Now, here is another thing about confidentiality that you probably never thought about. First, a quick question. Do you have a confidentiality clause in your PI contract? Wait. You do have a private investigator's contract, don't you? If you don't, or even if you do and you just need to tidy up some language, you may want to check out my Contracts for Private Investigators book. I will leave a link for it down below if you want more information. Now that I am done with my shameless plug of the day, here is that secret about confidentiality with your client. This secret can help you close the deal with the client and provide confidence in you as a professional private investigator. Make sure your contract has a confidentiality clause in it, and make sure you tell the prospective client that you are bound by confidentiality and you even guarantee it within your contract. I have been asked numerous times by clients about how they will know. I will not provide information to anyone else regarding the investigation. Once they realize I am bound not only by my license but also by my contract itself, it becomes much easier to close that deal with those worries out of the way. Now, really quick, let me say, I am not an attorney, nor do I play one on TV or YouTube for that matter, nor should anything in this video be construed as legal advice. Now, with that in mind, here is a sample confidentiality and non-disclosure clause you might consider adding to your PI contract. Confidentiality, non-disclosure. This portion of the agreement is for the purpose of preventing the unauthorized disclosure of confidential information as defined below. The parties agree to enter into a confidential relationship with respect to the disclosure of certain proprietary and confidential information. Definition of confidential information. For purposes of this agreement, confidential information shall include all information or material provided by the client to the agency, all information and material obtained during the investigation, and all information and material the agency provides to the client. Waiver of confidentiality. The client may waive his or her confidential rights to any, all, or partial information and materials by giving the agency written approval to waive such rights. Disclaimer. Agency shall not be held liable and shall be held harmless if agency releases confidential information or materials when ordered to under subpoena, summons, or other legally binding instrument of law ordered by a court of law. What other examples of legal verbiage can you think of that needs to be in a confidentiality clause? Go down in the comments below and let me know. I really do like hearing your feedback on these topics. Hey, here are 2 more videos I made just for you. And remember, folks, remember, stay safe out there.